I'm Stephen Burley, a judge of the Federal Court and a director of Mines Count. I'd like to commence by acknowledging the Gadigal people of the Eora Nation, the traditional owners of and custodians of the land upon which we meet in Sydney, and pay my respects to their elders past and present. It's my pleasant duty this evening to welcome you and otherwise to say almost nothing of substance. Tonight is the highlight of the Mines Count calendar, the keynote event, and it's wonderful to see so many people here in person and also to see that there are so many people attending virtually throughout Australia. I'd like to convey the apologies of Chief Justice Deborah Mortimer, our recently appointed Chief Justice, who is unable to attend tonight. She reassures us that the Court continues to adhere to the TJMF guidelines for the protection and promotion of psychological health and safety in the workplace, and in particular in legal workplaces. I'd also like to welcome Justice Stephen Gagler, Chief Justice Designate of the High Court, and congratulate him on his appointment, and to welcome him and thank him for coming tonight, and all of my judicial colleagues who are here. Tonight's keynote presentation is entitled Burning Bright Without Burning Out. And as usual, Justice Jagot has nailed the landing on the title. I'm sure we're all intrigued to hear how the conundrum of achieving well in a profession that demands as much as the legal profession does of us, and at the same time managing the pressures of anxiety and depression and so forth which come with those demands. Perhaps some of you here tonight thought twice before coming along and devoting time to this presentation rather than doing the demands that the work required of you in order to get through the day. Well, let me assure you that having seen what's to come, it was well worthwhile, and it will be well worthwhile. A wonderful presentation followed by an intriguing discussion which will help us, perhaps help ourselves a little bit and help our colleagues. So welcome to the Court and to tonight's event. I'll hand over now to Mel Upton, the chairperson of Mines Count, who will introduce our speakers and tell you something of substance.
Thank you, Justice Burley, for your opening comments and your leadership. And it's wonderful to have you around the board table as well. Justice Jagot just gave me the eye, which means she loves to start promptly, so I'll be very as quick as I can. But on behalf of the Board of Mines Count, I'm pleased to welcome you to the 2023 Mines Count Annual Lecture. Thank you so much for taking the time to join us either in person tonight or via our live stream. We don't want to forget those that are commuting, listening, or watching from their offices or other environments, but it's fabulous that you've taken the effort to join us, what will be an important discussion tonight. We will hear from our guest speaker from the High Court of Australia, Justice Jayne Jagot, who I'll introduce shortly. And the keynote will be followed by a panel discussion with Her Honour, Peter Dunning, President of the Australian Bar Association, and Fiona McLeay, CEO and Commissioner of the Victorian Legal Services Board. And I thank you both for very much for making your way this evening. The panel and the Q&A will be led by Mines Count friend and fabulous professional Danielle Kelly, Director of Culture and Inclusion at Herbert Freehills. I've already mentioned who's in the room, and I don't know if that was a good thing, Danielle, or not, but you're going to do a stellar job. It'll be a wonderful discussion. We hope to finish promptly, and it would be wonderful if you could join us for some refreshments in the next room. I know going from last year, we had to sort of push people out the door, so there's an opportunity to have really good conversation, reconnect with those that you haven't seen for some time, and make some new friends as well. So it is my great pleasure to introduce the keynote speaker this evening. Justice Jayne Jagot was appointed a Justice of the High Court of Australia in 2022, practiced as a solicitor from 1991 to 2002 and as a barrister from 2002 to 2006. Justice Jagot was a judge of the Land and Environment Court of New South Wales from 2006 to 2008 and a judge of the Federal Court of Australia from 2008 to 2022. Justice Jagot is also a former director of the Mines Count Foundation and remains a dear friend of the foundation and its directors. In tonight's event, Burning Bright Without Burning Out, Justice Jagot will be talking with us about the experience of law students and young lawyers at university and in the workplace, why legal workplaces might cause burnout, systematic and cultural forces, and workplace behaviours important to wellbeing. Our panel will then assemble, with the guidance of Danielle, as I mentioned, to canvass the systematic drivers and calls to action for the legal profession in addressing such issues. I'll now hand over to Justice Jagot to deliver the Minds Count lecture for 2023. Enjoy.
Well, thank you very much to Justice Burley, particularly for the acknowledgement to country, and to Mel for the introduction. I should say immediately that the only reason I gave Mel the eye there was nothing to do with time, actually. It was because I had nothing to do with the title Burning Bright Without Burning Out. I'm thinking I shouldn't take credit for that at all. Someone else came up with that, and I think it might have been Mel.
Collective effort.
Collective effort, okay. So just correct that error immediately. All right, well, thanks for joining us tonight. My basic topic is that, people here probably know that the law does provide an absolutely fascinating and potentially highly rewarding career, but we also know that we're routinely informed that we're more miserable, more stressed, more distressed, more anxious and more depressed than most other professions, as I understand it, apparently other than medicine. And my question to myself is, how can that be? The law provides us an opportunity for work that's intellectually stimulating at all parts of our legal career. It involves the potential for continuous improvement and development. It exposes legal practitioners to all manner of people, all manner of problems. It actively engages us in solving problems for other people. It enables us to help people when they need it most. We're actively involved in upholding the rule of law in modern liberal democracies, and they depend on the rule of law for their very existence. So when we put those together, there seems to just be a bit of a disjunction. I'm going to try to just hazard a few guesses as to why both things can be true at the same time. So my first proposition is, becoming qualified to be a lawyer. So it goes without saying, entry to law, certainly over the past few decades, has become more and more highly competitive. The courses themselves are highly competitive. We have to add to it now that law degrees are expensive. And I know that the costs can be deferred under the HEC scheme, but I also know that day-to-day living costs can't be deferred. And not all students have families capable of supporting them for the length of time it takes to get a law degree, let alone if they're doing it, as a graduate and on top of a first degree. I know from talking to people that failing a course and having to repeat it can be the difference for some people between being able to continue and complete their degree and not being able to complete their degree at all because of the additional cost. I also know, just from dealing with young people, that for many of them today, they have to work sufficient hours to pay for their food and rent, and they're also trying to both study and pass courses, but they're also trying to excel given the high level of competition. And that's just, the reality is, an enormously stressful thing for many people. For some people, I think we need to recognise that even the prospect of starting life with so much debt from tuition costs can operate as a material deterrent to undertaking that kind of tertiary education. So I think it should still be recognised that there are significant barriers to entry to the legal profession still. They either exclude people altogether, or if you can get over the initial barrier, it does impose great stresses on people, particularly people from relatively disadvantaged social and economic backgrounds who would make fine lawyers. I suspect the people who do overcome the barriers in entry and make it through their degree, particularly if they've come from that relative position of disadvantage, probably are carrying quite a high stress load before they even get to the professional legal workplace. And I'm not sure that our systems are developed yet to recognise that fact. Okay, next topic, entering legal practice. So you finish your degree, you've got to find a job. Now, again, for many, many young people, this can involve real hurdles. If they don't know anybody in the law, getting a foot in the door is really tough, particularly if, as routinely happens, the economy's on a bit of a downswing and the legal sector has contracted. It's tough for these young people. And I have to say, when I graduated, it actually never occurred to me, not even for a second, that a person like me, who knew absolutely no one in the law, could, for example, become a judge's associate or a barrister. Those thoughts never entered my head at that time. The reason? Frankly, I had no inherited legal cultural capital. I had absolutely no idea how to get any. I was a very retiring kind of person at university, so I hadn't acquired the kind of mentors that some other people from my circumstances do acquire, which provides them with that sort of opening up and pathway to entry. So for me, all that had to happen much later. And there've got to be lots of people in the same position today. Okay, next, many law graduates, of course, enter private practice. It absorbs a lot of lawyers. And I think it's got to be said that most of them will find that the performance pressure in private practice is just as intense as it has been at university. So they're still under that. They can't take a breath and say, I've made it. They've still got to perform at a very high level. The other thing about private practice is the reality is that many of them find that they just don't have the time to do anything other than work, sleep and eat, and that's it. There's also a couple of other aspects that I think are fairly common to some kinds of legal workplaces, and that is quite extreme hierarchy is a feature of the law. There's also a kind of relative pay differential between those at the top and those at the bottom of the pecking order. And it just seems to me, if you've got that kind of environment, then junior lawyers really have little autonomy over what they do. Their time is literally of lesser value than the time of the people above them in the pecking order. And I think it just should be accepted that that kind of environment is one where there's inherent within it a risk to psychological well-being. It's the kind of risk which I suspect needs to be recognised so you can actively manage it at all times. Okay, so why do legal workplaces cause burnout? There's a 2009 book which was very interesting. Many of you have probably read it, The Spirit Level, Why More Equal Societies Almost Always Do Better. And the authors of that book focus not on absolute inequalities, but on relative inequalities within societies. And their basic thesis is that on all sorts of measures, health, mental health, physical health, drug use, imprisonment, homicide rates, teenage birth rates, school dropout rates, school performance rates, infant mortality rates, social mobility, life expectancy, they're dictated more by relativities within a society than absolutes between comparing separate societies with each other. And I think it might help if we kind of look at legal workplaces as sort of microcosms of quite unequal societies. And these same kind of dynamics are in play. So I found I think, pretty good definition of burnout, which was from 2016 article. There will be a paper that Minds Count will get, and this will all be on there. It's described as a psychological syndrome emerging as a prolonged response to chronic interpersonal stresses on the job. It has 3 key dimensions: overwhelming exhaustion, I can relate to that one, feelings of cynicism and detachment from the job, and a sense of ineffectiveness and lack of accomplishment. Now, I would say that at various times of people's lives as lawyers, they're probably going to experience at least one of them, at least at one time. So I guess my message is, if we're serious about protecting people's mental health in the legal profession, we do need to take a critical look at the culture of legal workplaces. So my first elephant in the room, of course, is work hours, which I think are a huge systemic issue. I'm not talking about exceptional peak periods. I'm talking about the routine baseline work hours that people are expected to work. I think that we're fooling ourselves if we don't immediately acknowledge that people's routine work hours really matter. If they're working long hours, they're not getting weekends to recover because they're doing weekend work, and they don't take regular holidays, then over the long term, many people find that just simply unsustainable. and that is, to me, an obvious cause of burnout. Systemic issues to me include, and I've identified I think about 3 of them. Anyway, not time costing per se, it's a workplace culture in which the billable recoverable hours effectively determine everything about the culture in terms of the system of expectations and rewards. So salary, promotions, payment of bonuses, what's perceived as acceptable or even tolerated behaviours within the workplace. If everything's determined by billables or recoverables, then you start to get these kind of issues. Also, if you put that with a lack of a system of expectation and rewards which relate to other values, then you get a kind of exacerbating approach. Other values, high-level expertise, quality of work output, ethical and effective leadership, ethical and effective mentoring, pro bono contributions, academic contributions. Are they taken into account in the system of the rewards that really matter to people, which of course are salary and promotions? Then the other issue is expectations of standard unreasonable work hours, along with availability outside of traditional work hours being a norm, and therefore not merely acceptable, but in a sense culturally demanded of people. So there's also space in the room for another element, which is simply that if a main driver of profit is the leveraging of other people's time, and we all know, young lawyers make or earn far less than they make, then you do have to obviously take care to avoid any culture which is driving towards exploitation of people. You have to take active steps to guard against it. Now, these are large systemic issues, and I understand they might be beyond our individual influence, but of course they're not beyond the collective influence of those people who have power in legal workplaces. I don't want to diminish the significance of any of these issues because they seem to me to be the obvious big issues that systemically require consideration of how do you manage to take steps to work against the dynamic that they might otherwise cause. Of course, no matter how little we feel we can influence systemic issues, we also have a personal responsibility for our own workplace relationships with people. And I'm going to move to that topic. And what I'd really like to focus on here is something I mentioned, which is most, not all, but most legal workplaces are very hierarchical. And when you set up that kind of hierarchical relationship, we all have to recognise that, the people below us, who happen to be below us in the hierarchy at that particular time, stand to be, the most harmed by not just deliberate actions, but just lack of thought, lack of care. I'm going to, a quote here that I found, which is full of psychological jargon, but I think actually it's pretty accurate. It's from a paper from 2012. Anyway, it refers to externalising disorders, mania proneness, and narcissistic traits seem to be related to heightened dominance motivation and inflated self-perceptions of power. In contrast, anxiety and depression are related to subordination and submissiveness, as well as a desire to avoid subordination. So I'm thinking, well, if you look at sort of traditional legal workplaces through that kind of lens, then conduct which is sometimes hard to understand actually begins to make more sense. If we can see some kind of behaviours as a kind of manifestation of these kind of power relationships in hierarchies, then even if they're entirely unconsciously motivated behaviours, we can perhaps understand them better, including our own behaviours. So I thought long and hard about, okay, what are the kind of everyday behaviours? And I'm not talking here about overt bullying or harassment or sexual harassment, because they're kind of, to me, in an obvious misconduct category. I'm talking about kinds of behaviours that become pretty routine and normalised so that their potential adverse impacts can go unnoticed, but they are still, I think, a manifestation of a kind of the hierarchy of the workplace. Now, we might have engaged in one of these behaviours, I know I have, we might have been subjected to them. Years have gone by, and I think I'm coming to realise that these are quite unhelpful kinds of behaviours. Taken me a long time. And what I've also recognised is from the perspective of a junior lawyer, culture is really determined by the people with whom they're immediately interacting. So one law firm, particularly a big one, might have multiple legal cultures within it. And so you might get the junior lawyer over here who's having a great experience because they're working with great people, and another lawyer over here who's having quite a horrendous experience because there is a complete cultural difference between the two, because it's individual behaviours, not, you know, the policies on high, that are really dictating how this person experiences their day-to-day interactions with people. The other point I want to make is, I think this is pretty obvious, I think we're all acutely sensitive to power dynamics in every workplace. I think we all know that we know exactly where we stand in every work relationship. We know exactly where on the pegging we are. And that's why we should never underestimate the vulnerability and sensitivity of the people wherever they are, but if they're below us, they are going to be exceptionally vulnerable and sensitive to conduct, basically. So that's the given. Okay, so my 10 got 5 minutes here to get through them, 10 categories of behaviours. Okay, first one, the artificial deadline. It seems to me that if you're a junior person, you don't know why you've got to produce something by a particular time, potentially at great personal inconvenience. You're totally deprived of context and autonomy, and it seems to me that this is an obvious stressor. Second one, this is kind of like the variant of the artificial deadline. It's the artificial deadline where you add the unreasonable turnaround time for the person. So, of course, deadlines that are genuine, properly explicable, actually explained, are one thing altogether, perfectly fine. But artificial deadlines, when you put them with an unreasonable turnaround time, I just think something more's got to be going on there, and I suspect it is something to do with power, basically. I also think that people are maybe now at more risk if they've got a working from home kind of culture, because the separation between work time and home time has become so blurred. Okay, so my third one is one of my personal favourites. The person imposes the artificial deadline and or unreasonable turnaround time, but then they're not available at the time the work's needed to actually check the work and make sure it gets out. Fourth, I've got a kind of routine procrastination that means, and this is of the person who's imposed the task or given the task, but if the crunch comes and they haven't yet reviewed the work, and then everything's terribly urgent and under pressure of time because that person has sat on the work for an unreasonably long amount of time, I suspect that's, again, something more than just procrastination is going on there. I wonder whether it's a sort of unconscious expression of power, because it really does diminish the person who's done the work by not giving them the respect of dealing with the work. Okay, my fifth one is another goodie. It's keep people hanging around while I do something more important syndrome. I think this this involves the person with the lesser power is kept waiting. So they're either outside your office or worse, inside your office, while you do something completely separate from them altogether, like unrelated phone call, unrelated email answering, nothing to do with having them in, listening or being actively engaged. So as I say, it can be a phone call, reading a document, sending an email. I think it qualifies as something a bit odd, as long as it doesn't involve the person who's in there having to wait, thinking, why am I here captive to this kind of weird behaviour? Okay, my number six one. Fixing internal meetings at times outside standard working hours and without any form of consultation. So people have to make themselves available when they wouldn't otherwise be available. Of course, people want to be consulted and they like to have some choice in their life, and they do have other needs. So that makes it to 6 of my list. 7th, and I think a lot of junior lawyers will have experienced this one, it's kind of, we'll get together at 4 p.m. this afternoon and go through X. And then 4 p.m. comes, 4 p.m. goes, 6 p.m. comes, 6 p.m. goes, 8 p.m. comes, 8 p.m. goes, and the person doesn't have the capacity to say, look, I'd like to go home now, or I have to get home now, or I've got other commitments. And then, so the person again is a kind of captive to the timing of the other person. My 8th matter is sort of atomising legal work. So you give people tasks and you don't actually give them the context for what they're doing. I don't think anyone can do a proper job if they don't know context at all. 9th, I've got opposite of constructive feedback. So I've got certain dot points about this. So you convey you're dissatisfied with the work, but you don't tell people why. You actually make up new requirements after the work's been done. That one's a goodie. And you don't sort of fess up about it and say, actually, now that I've read it, I've realised I need something else. And then I'm guilty of this one. It's just easier if I redo the whole thing myself, kind of without really, giving the person a chance. Nitpicking and personalising negative feedback. As though it's somehow something to do with the person and their qualities as opposed to the work they happen to have produced in response to that particular request. My last one is taking credit for something or not giving credit where it's due to junior lawyers. This one's more in the obvious misconduct, but losing our temper in a sort of manifest, obvious way in the workplace. And not taking responsibility for our own mistakes. So I think if you're old enough, like me, you probably both experienced these things, probably engaged in some of these things, but we're all actually really keenly sensitive to these kinds of behaviours when we're on the receiving end of them. But I suspect because they're often, if people are stressed, this capacity to unconsciously sort of relieve stress in an inappropriate way occurs. So we're not as sensitive to, imposing these things on other people. And I guess an easy test is this, not one that I've always lived up to, of course, but if you wouldn't do it to someone who's above you, in the hierarchy, then I guess we should really be doing it to someone who's below you in the hierarchy, and that's an easy test. So how do we better guard against absorption into a workplace culture where there's kind of default settings that allow these things, including the big systemic issues I've talked about, to happen? I do think we all need to take a critical eye to the work culture and structure of which we're part, and whatever our individual capacity to influence or change culture, we do have a capacity to maintain our own keen awareness of the impacts of our own behaviours on other people. I don't think it's easy to maintain this. I'll remind you of one of my favourite quotes by George Eliot, where she says, the people around us all have an equivalent centre of self where the lights and shadows always fall with a certain difference. Trying to keep that in mind, it's something I've tried to keep in mind since I read that line. But of course, it's really hard to do if you're under pressure yourself, because that's when, you sort of lose that awareness, and under pressure yourself, these kind of, inappropriate ways of dealing with your own stress can come out. But we do need to give our more junior work colleagues the best opportunity to fulfil their potential and enjoy the fascinating, rewarding professional life the law can offer us. So at least if we think about these things, try to maintain that awareness. It could be a small but valuable step to help young lawyers, as the title says, burn bright but not burn out. The only other thing I'll say is this, it may sound a little cynical, but I think we should all remember, young lawyers will become the old lawyers, and one day they're going to have the power. And one day, not too far away, people like me will not have the power. So being kind to young lawyers is, of course, the decent thing to do, but it also just makes common sense. So thank you. I will hand over and ask... I think we're going to bring up Danielle, the panel. Thank you.
Is that working? Yep. Delighted to welcome our panel and thank you, Judge, for that insightful keynote. I think the way you framed it at the beginning there in terms of the purposeful nature of the profession, but then thinking about the polarity with then the corrosive nature of aspects of culture on people's mental health was beautifully framed. And I'm keen in this panel discussion to spend some time focusing on the leader's role in the legal workplace to provide a supportive, inclusive and high-performing environment, because I think they can all go together. So I'd like to start by introducing our panellists. Peter is a barrister in private practice, appearing and advising predominantly in commercial, constitutional and appellate matters throughout Australia. Peter took silk in 2005 and was the Solicitor General for Queensland between 2014 and 2019. Peter has been the President of the Australian Bar Association since last year. Fiona was appointed the Legal Services Commissioner and CEO of the Legal Services Board in 2018 and was reappointed to the role for a second 5-year term earlier this year. Fiona is the CEO of the Access to Justice organisation Justice Connect and has previously held the positions of General Counsel at World Vision Australia and Special Counsel at Clayton Utz, as well as a number of board roles, including Health Justice Australia and Equality Australia. So welcome to our panel. So I'd like to begin by reflecting on our agency to affect change. Justice Jagot spoke quite a lot about the systemic factors, but what is our own agency as leaders to affect change? I think it's fair to say that the legal profession has been focused on mental health and wellbeing for a number of years. It's a focus that when I first started practicing, no one had, but it's fair to say that in the last decade there have been many initiatives and conversations on the topic. And as the judge said, statistics are often cited about the profession's high rates of depression and anxiety. And so I guess I come to reflect on, do we spend too much time admiring the problem and honouring the perfectionistic A-type personality who is subject to the 24/7 demands of the client, a badge which perversely can rob us of our agency to affect change? And so how can we shift the conversation to one which genuinely interrogates the systems and structures within the profession which contribute to the problem? So perhaps, Judge, you'd like to lead.
I'm happy to contribute. I think the answer's absolutely yes in many legal workplaces. I include the bar and law firms in that. And it's because that kind of 24/7 availability or turnaround time or whatever, I think there's no doubt that that is still used as a selling point, to clients, that kind of, that you can provide that kind of capacity. So if that's a selling point to clients, then I think, as I mentioned in the speech, the system of expectations and rewards, which fixes the culture basically, is going to, reward that kind of, availability. So, I mean, who doesn't want a lawyer who's a perfectionist and available 24 hours a day? So I think there are two cultural dynamics here. one is the law firm sort of marketing itself, but two is the client and what, the interaction between them as to what does the client want. I did mention in the speech that I suspect that, if it were marketed right, clients would be very keen on, other dynamics of legal practice in terms of not so much the perfectionist A-type personality, but, ethical, effective legal work, excellent legal work, quality legal work. It seems to me that, you can lose sight of how marketable, I guess, those qualities are. A high degree of professionalism is not necessarily doesn't actually go together with perfectionist 24/7 availability, because just nobody can perform at that level, for that amount of time. So I suspect there's a real opportunity there for marketing that maybe people haven't fully considered yet. But definitely right now, my perception would be, yes, we still secretly laud the 24/7 perfectionist idea. That's my guess.
Thank you. Peter?
Well, my experience really as a barrister. I spent 18 months in a law firm and I've been at the bar ever since. And the bar, of course, is legendary for any barrister you bump into, whether it's Phillip Street, George Street, William Street, St George's Terrace, to say, busy. Can't believe how busy. I had so many cases, which apparently they think people are going to find interesting or remarkable. The reality is it's not. And when we talk about agency for change, I think it made a great impression on me in that short time I spent in the law firm. Was I worked in the insolvency group of a firm called Morris, Fletcher and Cross. And I worked for a somewhat laconic individual. And early on in the piece, he said to me, "Oh, Peter, a tour on the weekend." He just wanted to know one thing. We expect you to work about 10 hard hours a day, 5 days a week. And if you're spending more than that, then either you've got too much work, come and see me, we'll give some to somebody else, or you're moseying around coffee shops and things like that, you're not focused enough on it. And it's really stuck with me because Justice Jagot spoke about subcultures effectively within law firms. Now, the subculture I was in was a fantastic one. Short as it was, it made an enduring impression on me because they didn't champion ridiculously long hours. They championed good quality work. They championed working hard while you were at work. But it's always stuck with me that it's not the time you spend, it's how you spend your time. You do it well. You don't wander and drift off and think about other things. You're at work and you're focused on it. And we really want to deprecate this idea that I am so busy. It should be perfectly all right for someone to say, well, actually, I don't want to be so busy. My kids finished school, I don't need as much money as I used to. So no, look, my aim is to be away every Friday each week. And we need as a profession to embrace that as a pretty good idea.
Thanks, Peter. Fiona?
Yeah, thanks. So I think the first thing I would say is that change can happen, and I think it is happening. The fact that we're all sitting here in this room tonight, a sellout, people watching on the screen, tells me that there's a conversation happening that really wasn't happening 30 odd years ago when I first started working in and around the law. So I guess I would come at it from a kind of strengths, opportunities perspective in that regard. My role is as a regulator of lawyers in Victoria, so that's complaint handling, licensing, disciplining, trust account oversight, the whole box and dice. So I'm looking at, I guess, the system issues and pressures. One of the things that I did early on in this role was to start thinking hard about lawyer wellbeing. It's clear that there are challenges around that, and so we did a bit of a deep dive with some lawyers who shared their experience of life in the law, from students through to retired judges. And it was interesting listening to your remarks, Judge, and your 10 things. We came up with a kind of framing about the pressures that lawyers experience, the internal pressures associated with being a lawyer, the kinds of personality types that often find their way into law schools and then into firms, generate their own internal pressures. There's the horizontal pressures of the competitive nature of of the law, including when you're at law school and then getting into practice, building your practice, and then what we call the vertical pressures. So the pressures from clients, dare I say in this room, sometimes from judges, from all the people that are involved in telling a lawyer what they need to be doing. And so these three tiers all kind of coalesce into making life pretty challenging sometimes for lawyers. So it seemed to us as we stepped back and thought about that the conversation about resilient lawyers, which is one I think we're having more and more, is great, but that is really a starting point, and it certainly can't be the only part of the conversation, and it by no means the end. It's really a system problem that we're talking about here. And as I said, as a regulator, my bias is to think systemically, and so we need to be really looking at systemically what's going on. One of the ways that we're trying to do that is through our lawyer wellbeing project, and my colleague Lucy's in the room who's managing that, and we've established a thing that we're calling the wellbeing in the profession community of practice, and we've brought together organisational psychologists and other professionals in the area of wellbeing and health to talk about the specific issues as they relate to lawyers. Those people in the community of practice are all employed in legal contexts. The Law Institute of Victoria, for example, some law firms, the Office of the Public Prosecutor in Victoria, the Judicial College of Victoria, they all have people who are professionals in this area so that we can try and take a more systemic approach, identify some things that are working, some things we might want to try that can start to shift some of those system issues. So I think my short answer to the question is change can happen, it is happening, but we need to continue to look for the broader issues that are causing the problems.
Thanks, Fiona. I'd love to now turn the conversation to leaders and burnout, and we have the benefit of the definition you shared, Judge. Leaders increasingly need to be focused on a smorgasbord of performance domains, from clients to employee engagement and wellbeing to financial results, team cohesion, impact. And for these reasons, perhaps the narrative behind servant leadership is increasingly falling flat, because when leaders are tired and burnt out, overworked, serving can feel a bit like pouring from an empty cup. And so I wonder whether we're at an inflection point where leaders, both formal and informal, need to move towards a more purposeful leadership style that focus on the impact that the team's work has. And so where leaders and team members alike are in shared pursuit of a cause bigger than themselves. And I guess their goal is to positively impact their constituents versus serving them. As Lisa McLeod, the author of a recent Harvard Business Review article on the topic, said, when your North Star is a shared purpose, leaders have more choice in the matter. You don't feel as required to please everyone. So do you think the profession would do well to move from the long-held narrative of client service to one of client impact? Peter, would you like to start?
Look, I think yes, and in a sense it's always been a feature of the bar, and I suspect always a feature of the contentious side of a solicitor's branch of the profession. As I often say, excuse me, at the bar we are the ultimate grudge purchase. People get more satisfaction paying their panel beater than their barrister because we never impart good news. Something's gone wrong and you're there to salvage what you can from it. Now, in those circumstances, you are actually well placed to be able to say, well, look, this is your present predicament. Here are the likely ways forward. Here's realistically as good as I think it might get for you, and here's realistically as bad as I might get for you. Now, here are the risks along the way. What do you want to do? And that's really the nature of the work. Now, I never cease to be amazed at how, for the most part, most clients are quite on board with that. Now, there'll be moments of irritation, moments of screaming and ranting, and I hate her and hate him and he's terrible, and they want to run you through how terrible he is, probably right, who knows. But you actually get a lot further with, certainly in my experience of contentious work, you get a lot further by being really upfront with people and engaging with them as to, well, okay, well, here's where you are. here's where you'd like to get. Can't promise you're going to get there, but here's what strikes me as the most promising way of doing that. And it both works with a client and it works with the team of people you're trying to work with to get to that point, particularly given when the outcome might be not particularly great at the end, but just as good as you can achieve. And I think that applies everywhere, though, in terms of, if you take it out of the contentious field, that people are pretty realistic. When they come for legal services, they are buying something, just like they buy many other things. And deep down, I'm not sure they really do care if they're told it's 24/7.
Thanks, Peter. Fiona, what about from a regulator's viewpoint?
Yeah, a couple of points. I think I was reminded, Judge, when you're going through your list of, I think it was the arbitrary and unrealistic deadline of a time when I was in private practice, where we met with a client, a fairly large group of us and the senior partner, and agreed on the task. And the partner said to the client, when would you like the work? And the client said, I don't know, next Thursday, something like that. And the partner said, how about Monday? And there was this shiver that went down the spines of all of us, because we knew what that meant. That meant, a miserable weekend. And I remember thinking at the time, why would you say that? Later on in my career, as you heard, I worked as general counsel, where I was on the other side of the table briefing lawyers, and I learned then that it's probably very unlikely that client would have in fact read the information, the advice we prepared and delivered on Monday, because he'd said he needed it on Thursday, and he probably had 57 other things he was going to attend to. So it probably sat on his desk for 3 days. So the point of that anecdote is just to say that to the extent that was an example of that partner trying to deliver good client service, he wasn't actually understanding really what his client needed. As a regulator, we see that a lot, where lawyers get themselves into a pickle because they convey legal information to the client, sometimes accurate, often accurate, correct, but they haven't actually understood the question that the client has, and so there's this miss, and you get unhappy clients who complain and don't want to pay their bill, and people get upset about that. The final thing I would say is that I've always in my career strongly advocated that the law is bigger than just the individual client that you are serving. The law is a profession. One of the theories of profession is that it's about service to the community, that ethic of service. One of the reasons that lawyers enjoy the monopoly they have is because there's a public service element to it. So connecting into that bigger picture, Justice Jagot mentioned our role in the rule of law. It's fundamental to what we do as lawyers. It's one of the things we look at too when we regulate. Lawyers' obligation to the client, but their first obligation is to the court and to the administration of justice. And if you can remain connected into that can help, I think, to balance out some of these tricky situations, and to even the scales, so that you're bringing a broader perspective. And different lawyers will find that in different ways. I did a lot of pro bono work throughout my career and found that very satisfying, both for the individuals that I was able to help, but also that sense of connection back into the ethic of what it meant to be a lawyer and a professional.
Thanks, Fiona. And I think your anecdote about the partner spoke very much to the power dynamic that you spoke about. Judge, would you like to add any comments?
The only thing I'd like to add, I actually had to do some research today in order to understand what noble purpose leadership actually was. And what I worked out from my enormous 15 minutes of reading was a kind of, I know nothing about management, let me make that clear, but, service or servant sort of leadership, as I understand it, actually was pretty radical itself, because, it was, you have sort of command and control kind of leadership. As I say, I'm talking from 15 minutes detailed research here. And we just get told, do X, do Y. The idea of the leader as a servant of the team. What do you need, from me in order to make you all more effective? And then apparently noble purpose is, where the team is working together towards and seen as working towards a particular goal. But what I gathered in my enormous effort today was, that kind of leadership, which would be great, but I think it also depends on a much less hierarchical work structure. I'm not sure how you get that in a traditional hierarchical work structure, which seems to me to be much more, tending towards, frankly, not just a service, but back to a command and control kind of, so I'm not sure if there's some kind of evolution of management, towards a noble purpose. I don't know that, a very hierarchical work structure has gone through the second evolutionary phase, let alone the third. But anyway, that's just a little observation from a position of total ignorance.
Yeah, I think you make a great point. The profession was built from an apprenticeship model, which clearly is different. Fiona, if we can go back to you, you mentioned before the lawyer wellbeing project that the Victoria Legal Services Board commissioned in 2019, and I read that around 2/3 of the respondents offered suggestions for improving wellbeing in the profession. I'm interested in what were one or two that particularly struck you as something that the profession could or should do or do more of.
Yeah, sure. So there were a couple of them. Some of them already we've talked about, so I won't labour those. I think we have been talking about leadership and managers and management, and I think there was a recurring theme that there needed to be more emphasis on the management side of legal practice. It's not always something that lawyers make the time for or see the importance of. Some of the larger firms do have good programs that they put their people through as they become more senior, and that's terrific. It can be more difficult if you're in a smaller firm or in sole practice, where the day-to-day realities of servicing clients, keeping the lights on, can be quite overwhelming, and often there's not a lot of training that is provided to help lawyers do that. So I think that emphasis on legal workplaces where people are able to be supported by managers who are trained well. I think also that seeing wellbeing as really a health and safety issue, which it is, and it's just as important as the legal practice obligations. And from where I sit as a regulator, I see that play out, because unwell lawyers are not lawyers who are performing at their best. We see lawyers who get into trouble because they are overworked and they're stressed, they make mistakes. Even worse, they then try to cover up the mistake, which turns an awkward situation into a serious situation. And they're really quite sad, those cases, when we see those. So unwell lawyers don't listen as well as they can. They don't engage as well with their colleagues as they can, a whole range of things. So I think we need to start seeing this as really core to practice. I think also I've reflected a few times over the last few years, if you think about it as a health and safety issue, which it is, there's other sectors of the economy where they have taken health and safety very seriously. So my own father was a toolmaker, and I can remember as a very young child him coming home from work with an injury to his eye because some hot metal had got into his eye. That was not such an uncommon thing in factories in the early 70s. But now if you go to a manufacturing plant or a mining site, there'll be signs up that'll say, 3,000 days injury free, and there hasn't been, if there's a death on a workplace, that's a really big deal. And those industries and sectors of the economy have decided that it's not acceptable for people to be injured at work. And so I think that there are things that the profession can learn from the approach that other sectors of the economy have taken to these issues. The third thing that we've been really looking at through this project is early career lawyers and lawyers who are in that supervised practice part of their career. We know that's really critically important. Those of us that have worked with lawyers, I hope, can still remember the sheer terror that is the first year of practice, when you come out of law school thinking that you know something useful and discover, in fact, that you don't, or at least that you don't have the capacity to tell anybody all of the useful things that you learn in law school. So it's a very steep learning curve, and it's just so important that lawyers are well supervised and supported in that early phase of their career. So we have found through some research that we did recently with those early career lawyers that they do report, at least in Victoria, around 60% that supervised legal practice phase did help them develop the skills that they need, and that they were getting a good amount of time with their supervisors, particularly around their day-to-day support and their professional tasks. So that was great. The flip side of it, though, that only around a third of them felt that they could approach their supervisors for support to manage their stress and well-being. So good access for the professional side of what they're doing. Not such good access in relation to their well-being. Less than half said their supervisor asked them about how they were going, how was their well-being, how they coping okay. And nearly 40% reported that they experienced challenging behaviours from their supervisors. So this is an area that we're continuing to look at. We'll do some more research, and we want to develop up some materials and some interventions there to help that first few years of practice be a better one, and that will be working obviously with the younger lawyers, but equally importantly with those lawyers who are supervising younger lawyers.
Thanks, Fiona. We've commented a few times this evening on resilience, and certainly a lot has been written and said about resilience, and obviously many organisations, many law firms offer mindfulness workshops, yoga and the like, all in an effort to improve individual resilience. And while worthy in and of themselves, is there a risk that such interventions could end up being busy work, which could prevent the workplace from shining a light on its own culture, a kind of, I guess, performative well-being, which might mask the need for the type of cultural change that we've been talking about? And I ask this in the context of some research that came out last year from Professor Sull at the University of Michigan. And he found that the single best predictor of attrition in the workplace is in fact a toxic workplace culture, rather than more tangible or obvious things like pay or benefits. He also found that the hallmark of a toxic workplace culture is exclusion or lack of inclusion. So surely workplace culture needs to be back up at the top of the agenda, particularly in light of the new positive duty on employers to take all reasonable steps to prevent the risk of psychosocial harm. So Peter, does this resonate for you?
It does, and I think there are two key things if you want to attack a toxic workplace culture. The first is leadership. The more senior you are, the more it's upon you to make sure that you set an example, because the fish stinks from the head down, not the tail up. And how you behave, and I mean behave to everybody, not just the person who reports directly to you, but all of those people. Not always can you remember their name in the conference, but you can wing it and still make them feel involved. How you speak to the support staff, all of those things actually matter. They reverberate entirely through an organisation. I'm talking an organisation where I've got a couple of juniors and the solicitors, but the same would apply, I'd have thought, even more so in relation to law firms. So the first thing is leadership. It is, I just don't think it can be understated how important it is for people who look as old as I look to actually make sure that they set an example. And it does matter. I have seen it. I've known. I've been in cases where I've had juniors who I know are a bit aggressive and confronting, at least by my standards, and they are different if they are around you. And I've never said anything to them, but they are, and it matters. The second thing is personal responsibility. Wherever you are in the pecking order, as Justice Jagot said, in the end, relativity is what matters. So you personally need to make sure that your behaviour is the sort of behaviour you would like reflected back to you. And if you want to attack a toxic culture, those are the two things that I think actually make a difference. And you need to want to attack a toxic culture, because certainly from the point of view of running a case, if you're a barrister, if you do have that among your team, the whole thing's a disaster, particularly if you're the person on your feet, because you just won't make any progress. Those people who are part of the cohort that are dealing with your problem, you need to engage them. And if you're going to engage them, you need to treat them respectfully in the way you'd like to be treated. That doesn't mean you can't direct their attention to things that haven't been done to the standards you're seeking, or that something will need to be done by time. But just as Jago said, if there's a deadline, explain to them why it matters. If you ask them to prepare some brutally tedious chronology, spend 5 minutes with them at the beginning to say, this is why this is going to matter to this case. This is how I am planning to use this in this case. And you'll get a much better product as a result. So they're, to my mind, with daylight third, the two most important things for attacking a toxic culture.
Thanks, Peter. Justice Jago.
Just two observations. I did, again, look up Professor Sol's work, so I knew what on earth we were talking about. But I felt good because he identified the people who did this work, research, identified on my reading something they called the toxic five, and they were in a kind of order. And the first and most overwhelming one apparently was a disrespectful workplace. And I thought, well, that actually seems to fit in almost, I think probably everything I was saying was about sort of respecting people and seeing the dignity in every person. So they had disrespectful, by far number one apparently. Then I'm not sure if these are in order, but it was non-inclusive, unethical, cutthroat, and they gave examples of kind of backstabbing or ruthless workplace, and abusive workplace. But by far the first one was I just think it's easier. I think disrespect can sort of, as I say, it's not obvious misconduct, it's just kind of an interactive style, and therefore you can slip into it more easily. And also, of course, if you're under enormous pressure yourself, I think it just can come out more easily for a lot of people than, turning into an abusive, bully. I mean, not many of us have that in us, but disrespect, I think we're all at risk of slipping into that kind of dealing with people when we're under stress. The only other observation I want to make is, and you were talking about resilience and performative wellbeing. I know you're going to come to this, I can see, but I have to say, I'm not trying to downgrade resilience, but I think the idea of individual resilience is kind of, to me, a bit dangerous, because it so much puts the onus on the individual to be resilient, as opposed to on the culture to enable people to be their best self. So I just find it a little bit kind of dangerous in the workplace sort of culture. I know you're going to come to that, so I'll leave it there.
Thank you. Fiona.
Yeah, so in case you hadn't picked it up, I'm a bit of a data fiend. So I have this aphorism that data is not the plural of anecdote. Just think about that. So again, we did another survey, 2021, where we asked lawyers about the impact that their workplace culture had on their wellbeing. And there was some good news. About 75% said that their organisational culture had a more positive than negative impact on their personal wellbeing. And the things that contributed to their wellbeing, these will be unsurprising, but some data: supportive colleagues, flexible working arrangements, reasonable work-life balance. They're all in the kind of 60 to 80% of people saying that's what makes it really good. Supportive management, only about 55% actually, so that's interesting for people in management to ponder. And a culture that doesn't tolerate bullying or discrimination. So then the flip side, what contributed to negative experiences of wellbeing? Unreasonable workloads, poor work-life balance, long work hours, a hypercritical culture, and a lack of collegiality, and we might talk about that a bit later on. For younger lawyers in that 21 to 30 year age bracket, a lack of training and professional development was also a commonly reported negative factor. And unreasonable workloads were more of an issue for lawyers in that between the ages of 21 to 50 years, compared to those who were 51 to 70 years old. So that's also interesting to think about. So no real surprises there, but some data to support anecdote, and I think really underpins the work of Professor Sol. There's a really good McKinsey global study on toxic workplace behaviour from 2020, which also Google that if you're interested. There's lots of really clear data that an unhealthy workplace culture is really bad for people.
And certainly bad for high performance as well, in case people think that their polarities Many of you will be familiar with Professor Ian Hickey's work. He originally co-authored the 2009 Courting the Blues report on mental health in the profession and now head of the University of Sydney's Brain and Mind Centre. Speaking of resilience, he talks of resilience as being better conceptualised as a group characteristic or a product of teamwork, which I think supports your comments, Judge. Becoming resilient, he said, isn't about becoming bulletproof. It's more about being embedded within a community, supporting others when they struggle, but also accepting help yourself when times are tough. Speaking at the Law Society of New South Wales conference a couple of years ago, he said that the legal profession needs to focus on collective rather than individual resilience, to your point, and that this requires a level of cohesiveness, collegiality and transgenerational support that perhaps has waned in the profession in recent years. And he also talked about how a sense of purpose and belonging is critical to a mentally wealthy profession where support, care and flexibility underpin how we relate to each other. So my question is a somewhat broad one, but how do we increase that cohesiveness, that collegiality, that transgenerational support in firms and the profession so as to increase our overall mental wealth and thereby reduce burnout? I don't know who'd like to kick us off.
I'm happy to kick off on that one. So I think collegiality is one of the things I say to young lawyers and law students. It's one of the great things about the profession. It's collegiate, and that is, again, I think a marker of what it means to be a profession. But I think it's perhaps challenging in the 21st century in maybe ways that it wasn't in the 19th century. It's easier to be collegiate with people who look like you, who come from the same social background as you, who have the same educational background as you, the same pathway to the profession. But we're now in a very diverse world, which is a great thing, and the profession is increasingly reflecting the community that it serves. I have data on that too, but I won't bore you with that. And so that's a really good thing, but I think it also challenges us in terms of collegiality, making sure that we are looking around to see who perhaps isn't naturally in a collegiate group, making sure they're not missing out. And so if you're in a structured law firm context, you should be looking for cultures of inclusivity and support in a kind of formal, structured way. For people who are working in smaller practices or on their own, there's lots of good stuff that you can get by connecting in with your professional associations who can help with that. But really thinking about with whom am I being collegiate and who's perhaps missing out on that. We've talked about the importance of leadership, education and training as well as being really critical in this area.
Peter, did you want to talk about this from the perspective of the bar?
Look, from the perspective of the bar, I'd really return to my answer to the earlier question. If you want to promote collegiality, be collegiate in your conduct. Be polite to people. Be inclusive to people. Be free from prejudice of any kind. Now, we've all got our prejudices, there's no doubt about that. It's accepting that you know they're there and making sure that you deal with them. And certainly from the bar's point of view, it greatly enhances performance. Like, as I say, it's you on your feet. And if Justice Jagot or Justice Bromwich doesn't like it, they'll soon let me know, politely, of course, but they'll soon let me know. But I'm the one who wears the responsibility for that. Now, if I want to manage that, these people I've got around me, I've got to harness what they've got. And if I'm going to harness what they've got, I've got to speak to them nicely. I've got to explain to them why we're doing it. As I say, you will give, particularly the more junior people, absolutely mind-numbing tasks. You remember yourself from when you were there and you think, oh my God, it's every bit as tedious as it was 30 years ago when I was doing it. But if you engage them, and here's why you're doing it, and here's how we're going to use it, at that end, and at the other end, share the victory, share the glory. Like, if a cross-examination goes really well, sure, it reflects on the person who was speaking, but a really stunning cross-examination will be the product of a lot of people. So make sure when you walk out of court, you thank the junior. You go and you find and thank that person who you've barely seen, or say, look, can you thank X, who's been back in the solicitor's office, ruthlessly pumping out documents for me. And on the bad days, and in this line of work, there are plenty of them. On the bad days, you all share the loss. So if one particular part of the case didn't go well, no one person owns that. Yet on the day, it'll feel like that. This witness was left to X to prepare and he was a dud. Or we didn't see this document. Somehow it just got missed. That's the day when the more senior you are, the more you got to step and say, no, we were doing this as a team. And we'll have good days and bad days. Today was a bad day. Tomorrow's a new day, and together we'll confront it like that. So if you want collegiality, be collegiate, and you will improve performance undoubtedly.
Peter. I'd like to now shift to the tension that we sometimes see between individual and collective mental health. And I think some workplaces are seeing this played out, particularly in a post-COVID world, where perhaps the decisions that an individual is making around where and when they work and work from home and that sort of thing can feel at times at the expense of the rest of the team. In other words, self-interest means that individual wellbeing can trump the collective team wellbeing. Do you see this happening? And how can we have better conversations with people about the impact of their own choices on team wellbeing? Judge, did you want to start us off there?
The only observation, I suppose, once you set up a dichotomy between, an individual and, others, then you tend to, see conflict, I guess. As I say, to go back to the previous question, obviously, from what I said, I far prefer Professor Hickey's conceptualisation of resilience as a kind of group characteristic or a group cultural thing, and not an individual quality that someone either, has or or doesn't have, or they're not resilient enough. So I really am in favour of that. But when you start to looking at it through his kind of perspective on kind of collective well-being, it should, I guess, and cohesiveness and things like that, it shouldn't really be about, if you get a plus, I'll get a minus, you know what I mean, in this kind of offsetting way. So I guess if you're thinking collectively, it's about, how do we accommodate, everybody as best we can, without sort of seeing every plus for one person as a minus. And is undoubtedly, in a group context, compromises have to be, you try to work out the best fit, for the overall well-being. So, big plus here, little minus there, so it's got to be about overall well-being. I mean, I know behind this is probably an issue of, more senior people maybe working from home, more junior people not getting the exposure that they would otherwise get, kinds of issues like that. But as I say, I just think, each team has to work out, what is for the overall best, way for that particular team, and maybe not to see every plus for one person as a minus for another.
And perhaps as a leadership opportunity to have a good conversation about that. I'd love to come back to, in some ways, to where we started around systemic change. And Judge, you talked about sort of three key factors of burnout being exhaustion, cynicism and overwhelm. And it strikes me that, if you're feeling those things, there's obviously going to be a marked decline in your own creativity and a corresponding increase in mindset rigidity. Which gets me thinking around the rate of change in the legal market, particularly as a result of AI, and you might argue that actually the need for creativity and innovation in the legal profession has never been greater. So the stakes are high when it comes to leaning into the issue of how we address the systemic factors leading to burnout. So I'm interested for the panel, for each of you, if you could make one key shift in the culture or work practices of the legal profession, what would it be? Can I start with you, Peter? And I suspect it's going to be something around respect.
Well, it is, but perhaps a little off that to this extent. If there's one thing I think we should change, it's this notion that I have to work very hard or I'm in a glamorous area of practice. The job we do is a privilege. To have somebody come to you with their problem or with their opportunity, depending on what area of practice, and entrust you to help them navigate, in particular, that problem, is a real privilege. And it's a shame if you don't feel like it's that. That doesn't mean you're not tired of bad days and good days, but it's a shame if you don't really achieve that. Key to achieving it is do what you like. No one area of practice is more glamorous than another area of practice. So if you like doing intellectual property work, do intellectual property work. If you like doing crime, do crime. If you like doing personal injuries work, do that, and don't have a sense that that's more or less glamorous than doing any other practice. It's not more or less glamorous to your client. You know, your client's predicament is as vital to them, whether they're an ASX 100 company or they're just a very person in very simple and ordinary circumstances. And if I could make a systemic change, we'd say to people, just make sure you enjoy your job. Like the opportunity, pick something you like doing and aim to do it well.
Fiona?
So I'm going to answer the question slightly differently. The thing that I think we should be doing is actually trying to work out what's working and what doesn't work. So given my comment about data, perhaps you won't be surprised to hear that. So one of the things that we're going to be doing through our Lawyer Wellbeing project is to actually establish some measures to measure and evaluate what actually might be working. The IBA did some research in 2021 on mental wellbeing in the profession, and one of the things they found was that 73% of firms have wellbeing initiatives in place, but only about a third of them measure whether that has any impact or collect any data to begin with. So things that, are a bit nerdy, but baselines, careful design. What is it that you think you're going to achieve by doing this thing, and then is it actually working or not? And if it's not, why not? And then adjust. So we're going to do some work on that and produce what we hope will be a really useful framework for the profession to be able to identify what works and what doesn't. I think the other thing I just would leave you with is a quote from Professor Nathalie Cadeau from the University of Sherbrooke in Canada, who did a really fantastic piece of research on lawyer wellbeing in Canada. And she says what we need for a healthy and sustainable practice of the law is small steps at all levels from all stakeholders. So I think that would be my kind of, parting message. It's everything, all of us working together, little steps.
Thank you. Judge, would you like to have the final say?
I don't think it's probably worth the final say on this question, but Fiona, in fact, already identified what I would like to see as if I could only have one key shift, and it was the way she focused on a kind of core ethic of legal professionalism. And I just think it's so easy, if you're in a world of you need to be technically excellent, you need to be focusing on client relationships. This is if you're in, private practice, or a law firm. You need to be winning work. You need to be responsible for your team. You're thinking about, if you're a young lawyer, promotions. You're thinking about bonuses. You're thinking about, if you're a partner of a law firm, profit. You've got all these things, demanding on you. And I just think it's so easy to lose sight of the key kind of core value when you've just got so many demands happening on you. So as I say, if you've got a system of sort of rewards and expectations that's taking care of all these other things, but you've still got to the system should be its centre has to remain, the profession and what makes it a profession. And Yeah, it might be a bit back to the future in a sense, because everybody will say, of course, you know, that those other demands now are so great in the modern environment that it's so much easier to lose the centre.
Thank you. Okay, we got a little over time, but do we have some time for Q&A? Yeah. So, Jerome, did you want to kick us off? Okay.
Sorry, everyone. Do we have any questions from the audience for our panellists? Yeah. Annabelle? So I'll run this over to you.
Hello. My name's Annabelle Biscotto. I'm the president of the Australian Law Students Association. I've been in this position since October of last year. I'm also a law student, and I'm on a leave of absence this year because I care about my mental health, and that's one of the things that I tried to do. In my capacity as president, I've had the privilege of being involved in, I think, the first collaborative review of Australian legal education. Obviously, it hasn't changed for a very long time. And so I've attended on behalf of ALSA and also had the privilege of discussing with 5 other stakeholders in the legal education space, I guess, on sort of what the law degree should look like in the future. Obviously, change is very slow, so there's a lot of sort of big ideas that we're discussing at the moment. But from the discussion tonight, which I think has been very helpful in my research and work, I guess, I have 2 sort of comments that I've sort of gathered from speaking to a lot of people, doing a lot of research, and discussing with my peers. I've run councils and sessions at conference, for example, to hear what other people have to say. And I guess the biggest one for me is the Priestley 11 and the requirements that we have of our law students these days, because obviously that has a flow-on effect to the rest of our career. And one of the things I'm very passionate about is helping students and figuring out ways that students can develop their own passions and interests in the law, because I think that the way the degree is structured at the moment, you sort of end up in one way, you sort of end up in private practice, and there's not a lot of scope to develop and explore what you're passionate about. So students sort of feel compelled to go into this, you know, down the sort of rabbit hole. They end up there in maybe 2-3 years and decide this isn't for them. And then that's when the sort of mental health issues become quite serious. I think if law students were in a career that they enjoy, that would be the difference between the normal sort of demands of, you know, our profession and burnout and experiencing more serious issues. I also think that we should have more units such as teaching leadership skills, for example, because when these students do end up in more senior roles, they have the knowledge to better serve the people underneath them, and they don't sort of fall into those behaviours that perpetuate this sort of culture that is kind of prevalent at the moment. And so I guess my question to you guys is, what would be sort of a structural change you would like to see in the law degree to minimise the negative impacts of, I guess, mental health in the legal profession?
Look, my response to that is probably not so much the law degree. Like, I did jurisprudence, and I can't say I enjoyed it yet. I know there are a few other things that I did as well that I didn't love. But the fact is, 30 years later, I actually realised that you need to understand the fabric of the law, and that actually means a broad-based understanding of the law. It doesn't matter what you're doing, you'll need some of that. The point you make, Annabelle, and make well if I may say so, is we need to address why it is some people are going on to love practicing law and others are not. And I think that probably has something to do at the law school stage, but I think much more importantly at that stage of, whether you call it PLT, whatever you call that, professional legal training, where we take somebody with a law degree and put them into somebody who can get a practicing certificate. I think it's at that point we really need to drive home those issues, and public education. And public education works in everything. It works everything from drink driving to domestic violence. If you want to improve the workplace culture, which is what we're getting to, public education, having the discussion is the key to it. That's my answer.
Just quickly from me, I think that the way we teach ethics in the degree needs to change. It's technical. It's very black letter. It's here's a bunch of lawyers who did a bad thing. This is how close to the line they got. Don't get that close to the line. The piece that is missing for me is what I was talking about before, and Justice Jagot mentioned as well. What does it mean to be a lawyer? What is this ethical profession that we are part of? And I think if we can give lawyers a better framework for understanding the way the law works and their role in it and the pressures that they'll face, that will help them make better choices as they navigate their way through. It'll help them cope with some of the issues that come up, which can be difficult to navigate without that broader framework, and it'll make them better lawyers. So I feel very passionate about this issue. I don't have a lot of capacity to influence, I've got to say, but that is the one thing I would change, is the way ethics is taught.
Oh, I can't really add to that. I mean, I think, ethics. I don't even know that I did ethics at university as part of a law degree. I actually don't even know it was part of the compulsory
It's not always
training. I mean, anyway, there we go. Frightening.
Got a question from Lara. And is Sue Gilchrist in the room? I understand she had a question as well. She's not. Okay, anyway, Lara.
Hello, my name is Lara Wentworth. I'll just move out of the way so I'm not standing in front of you. I was a lawyer for a long time, for about 20 years practicing family law, and then I moved into coaching and training for lawyers. Having experienced depression and anxiety myself throughout my career, I thought, giving back to the profession this way would really make a difference in my life. A statement, or I suppose an observation from my work, and also a question. I deal with a lot of lawyers who are suffering mental health, burnout, anxiety, and a whole heap of different stuff through the coaching work that I do. And I find that we work to build their resilience level. So we work to build their capacity to cope, their thinking, their believing, their feeling, all that internal, intrinsic stuff that helps them cope, be stronger people. And then they go back into a broken system. They go back into a culture that doesn't support them. They go back into a profession that doesn't help. And so it's really disheartening for me to see them sort of say, I'm trying. And so I'm seeing a lot of young lawyers vote with their feet, leave, start their own law firms, start to build different cultures. My question is, what will it take for us to not just be talking about this? What will it take for law firms, and I'm talking specifically in the private sector, what will it take for them to actually do something about it? Because we're not, I don't think it affects their bottom line, their profit when it comes to wellbeing. There's that sort of turn and churn culture for young people. They're not coping, we'll just get someone else who can. So what will it really take for us to do something about this? What will it take?
I don't mind. I don't know. It's a short answer. Just being, but I think I think it's probably a whole of profession sort of issue. It comes from right back to university degree, through professional legal training, through to all forms of legal workplaces. I don't have a magic answer to this, but the point about that Fiona made, and you'll know much more about this than I do, the idea that time moves on. It was okay in factories for people to get a bit of hot metal in their eye in the 1970s, but now it's totally unacceptable. It's a matter that goes right to the bottom line, and hey presto, everybody's wearing protective eyewear. But, if we can make this issue of psychological well-being, really embedded as a health and safety matter, and I suspect we're creeping towards it from events of the last 5 years, but we're creeping. but there does need to be some kind of shift so that it really, to me, centralises that is a part of health and safety. That is like a legal obligation to protect people's mental well-being. And as I say, over about 5 years, I genuinely can see a little bit of shifting, but yeah, I suspect, a big shove is needed.
Yeah, I think I agree with that. I think the other thing I would say is that I think there are changes happening, and so I encourage people who are feeling like that first of all, you sometimes have more agency than you think you do in those situations. So as difficult as it can be, and this obviously can't work for everyone, but sometimes you can say, look, actually that I can't work on the weekend, I'm sorry. And yeah, I remember having that conversation very nervously as a very young lawyer and actually getting a very positive response saying, well, that's fair enough. So I do always encourage people to try that if they feel that they can. But I think that extending from that, younger lawyers coming through now, I think they do have a greater sense of what's acceptable and how they want to work. And that does have an impact. So there are all sorts of interesting models of legal practice that are emerging, and they will get stronger and more competitive. So I guess I'm not as pessimistic about the possibility for change, although realistic about it as well.
The only thing I'd really add to that is, in the end, that's something that if you make employers compete for, it will make a difference. Because everybody asked, what's the place like to work for? And if it becomes an idea, well, actually, that's one of the things that I prioritise, employers will compete for it.
I think we've got time for just one more. Jade.
Thank you. My name is Jade Murphy. I'm a member at the Administrative Appeals Tribunal, and for the past few years I've been looking into judicial and decision maker wellbeing and resilience. So I guess my question would be mainly for Justice Jagot. In terms of the comments you've made tonight about wellbeing and resilience in the legal profession, how much of that is the same or how much of that is different in the context specifically for decision makers?
Well, I mean, if you're looking for a hierarchical workplace, you can't really go beyond a court, can you? So it's their places by definition of extreme hierarchy. So I think pretty much what I've said in terms of I'm not talking now about a judge dealing with parties and things. That's a whole other topic. But within the workplace itself, the thing, I think, exactly the same things apply. That the need for, I suspect the toxic five, would be the identical toxic five for a court, a judicial workplace. And like every workplace, they've got the same obligation, legal obligation, as any other workplace, to really centre that people's psychological well-being. So, being the judge, I guess, you're in a position at the top of that court hierarchy. So definitely, the points I was making about, well, everybody who's below you in that hierarchy, they are going to be incredibly sensitive to criticism. But of course, that I know that also applies vis-a-vis actual appearing, as Peter would say. But so I still think, what Professor Sull, I think, was it identified. I suspect that's just going to fit across workplaces, including courts.
Thank you so much to the panel. Sorry, I lost my microphone. Great discussion. And I'm conscious that we're in low time, so I'm going to hand to you now, Mel.
Thank you so much. I'll be very quick. But it was a fabulous conversation, and Danielle, you did a fantastic job. Just a couple of, you've all had one of these on your seats. This is the refreshed Tristan Jepson guidelines, and it's really intended to raise awareness of mental health issues and provide a medium for encouraging discussion of the highest priority needs in any given workplace. So I encourage you, it's been a lot of hard work invested in here, and David has been leading the charge, David Field, from a board perspective along with others. So it's a really great piece of work, and they're still very valid today. So I encourage you to take that and to share that within your organisation. Just a couple of thank yous. Again, awesome job, Danielle. I think you covered a lot of territory there. The responses were authentic, not controversial, I'd say. Not that I expected it, but also some humour in there too, and also some honesty that we don't have all the answers. But what is refreshing is that these conversations do take place, and it's fabulous to see the room full. And I suspect there's also a healthy level of attendees joining us virtually. And I think that does help create the change that we do need to make. It also means we have, from my perspective, top down, bottom up. So we have the leaders of today, and this was also covered, but we also have in this room leaders of the future. I was talking to a uni student who, year one, and I don't want that person in this room to be discouraged by some of the challenges that are ahead of you, because it is a real privilege to be in this profession, and we don't have all the answers. But I think to something that, Peter, you also mentioned too, it's a collective effort. We need to do it together, but we also need to shout out as leaders too when we don't get it right, and we need the help of others. And I suspect, as to what you also mentioned, this does take some change, and there are some very strong voices in this room, and I encourage you to continue the level of, I guess, curiosity, challenge, and also contribution, because we do, as senior leaders, need to hear and need to learn ourselves. Enough of my ranting. So I do want to thank Justice Jagot, Peter Dunting, Fiona McLeay for their time, reflections, insights this evening. Danielle, as I said, for fantastic facilitation. Justice Burley, Chief Justice Deborah Mortimer, the board, who are all here this evening, and to all of you, our important signatories, our peers, our friends, and those that are new to us. I hope that this is just the first of the lectures that you do attend. To our sponsors, it wouldn't have been possible without the generous support, and I thank Herbert Smith Freehills, McCabe's and Thomson Reuters Legal, who are all in the room this evening. We thank you for your generosity, your leadership in this space, and commitment to the profession, and the active role your organisations and people play. Thank you also to our volunteer ushers. They're all in the room, at the back of the room, I think, at the moment, and the BD support this evening from SWAB. John Hovelman, Maxine Bell, Jack Conquerin, Emma Dowman, Charlotte Horsley, Regina Robinson. You've been incredible again this year. It's always fabulous to see you, and we do thank you for your help during the course of the evening. Thank you everyone in this room, and obviously who have joined us live stream tonight. I want to actually, I don't know, is it up? There's a little code if you do feel inclined from a donation perspective for the board to continue its work. There it is there. But I do want to close proceedings now and ask all of you if you are available to join us for refreshments. But I do wish you a very, very good night. I do thank you for your attention this evening. Thank you so much.